Welcome to On the Beat, everyone. I'm over here with Sarah Cline Stevens, attorney at law, and today we're talking about conservatorships and guardianships in long-term care planning. Welcome to the show, my friend.
You.
Okay, when I see those two words, conservatorship and guardianship, I have a feeling it means a lot of power for that person over one's estate or life.
That's true, it is. And guardianships and conservatorships are processes that come into play when a person is living but may be unable to manage their affairs. So it's certainly at a point in time where the person is unable to make decisions for one reason or another. And this can be over adults or children or a person with a disability or someone who maybe has a cognitive impairment that's developed. But the courts have created these programs, guardianships and conservatorships, so that there's an avenue for protection for what we call now vulnerable adults.
Okay, so when we say vulnerable adults, explain to someone at home what that scenario would look like.
So a vulnerable adult might be somebody who was diagnosed with dementia, or maybe they've had a stroke and they're no longer able to handle their personal or financial affairs. That makes them subject to people who try to take financial advantage of them, identity thieves, scam artists, you know, maybe somebody who comes in and wants to mow the yard 2 or 3 times a week. And they don't have maybe the mental capacity to be able to understand that these expenses are not in their best interest. That's one avenue of that. Another one might be maybe they're not able to make sound medical decisions for themselves anymore. This is a process that comes into play when a person does not have appropriate estate planning documents in place, like a power of attorney or an appropriate advanced health care directive. If they no longer have the capacity to execute documents like that to protect themselves, then the court has to get involved so they can make sure that an appropriate person is appointed to make these types of important decisions.
So just by listening to you with what you're saying, I would assume you need to put these into place before anything happens to you.
Well, if you were able to put estate planning documents in place ahead of time, like we talked about a month or so ago, powers of attorney, advanced health care directives, then you might be able to avoid a conservatorship or a guardianship completely.
Oh, okay.
So this is really the last effort. You know, if somebody doesn't have estate planning, but the family needs somebody to come in and offer some protection, then the court's got to get involved and you have to make a decision who's the best person to make these types of decisions.
Okay, so I just want to break it down a little bit more. Is it the same as a power of attorney?
I call them superpowers of attorney.
Okay.
You know, and the big difference is a power of attorney is something that you personally execute and you say, I want my husband to be my power of attorney. If I'm unable to make decisions, he's the next best person. A conservatorship comes along when you aren't able to say who you want anymore.
Right, okay.
And so the court doesn't know, and therefore 2 doctors have to be involved that make a determination that, yes, you need assistance making these types of decisions. And then someone is petitioning the court to say, I want to serve in this capacity for Sarah so that I have her best interest in mind. So the court's going to make a determine if this is a good person or not.
Okay, and you would have to go to court?
Absolutely.
There's no choice, like your daughter can't come along and say, Mum, I'll look after you. Who's ordering you to go to court if you don't have those in place?
Right, there's a petition. Somebody is concerned in your family, and they file a petition with the court. The court then does require a hearing. The person who the conservatorship will be over must be served to come to court to make that type of decision. And then the person who's ultimately named the conservator of the guardian, they're required to post a bond, do accurate accountings and inventories to make sure the court wants to know that they're doing what's in your best interest. So that's why you need an appropriate attorney.
As powerful as those words mean, it also seems like you are protected at some level as well.
You are. The court wants you to make sure that you've got the appropriate person in place.
Well, Sarah, as always, great information. You really do give good information. If you want to find out more, there it all is up on the screen for you. Give Sarah a call. Back after this short break.